Thank you, Mayor and governing body. Joseph Ledbetter, and I come here as an attorney. Have a couple clients that have contacted me in the last week about their concerns about the ordinance. And so I'm talking directly about the ordinance that was referred to with page numbers. And I was going through it. Didn't have near as much time as I wanted. But I want to give background to some of this as well. Yes, as a neighborhood improvement officer and board member, I've heard many complaints over the years about code and code enforcement. What I've heard in Highcrest is they're more concerned they'd like to have a landlord code, that applies to landlords, because they see that as the number one problem in their NIA. But the fact that 15 other cities have adopted this, I don't know in what form, I don't know where it was amended, that probably is not impressive to me, especially if they're wealthier cities, like Overland Park and Lawrence, that don't have a lot of the poor homeowners that we do in this city, and a lot of the poor residents that we have in this city. In fact, poverty continues to grow in this city. It's not the glowing picture that we keep hearing. 1 in 4 of our kids in 501 is now living in poverty. That's a new statistic. We continue to lose jobs in this community, so that's affecting people's ability to repair their homes, and it's affecting people not having jobs to pay for maintenance. Now, on page 13, you talk about there will be an administrative penalty of $100 imposed on owners of vehicles that are inoperable. Just want to put this on the record so you know what you're actually talking about, these amounts. On page 14, you're talking about general violations. The administrative cost will be $140. So I'm assuming that's in addition to any other fines that may be levied. On page 15, you talk about a reasonable time shall not exceed 60 calendar days. And I'm going, if they need to do exterior painting, how are they going to do that in the winter? It doesn't stick above or below 45 degrees, basically, if you look at any can of paint. We had a very long winter. You weren't doing a lot of street repairs during some of those months, so you're going to expect homeowners to perform exterior repairs during those months in the same fashion, as a street department or as some ambiguous term of 60 days. And when I say ambiguous, I mean it's really not ambiguous, it's impossible, depending on the weather. I really think you need to address that. I think you need to talk about times of year, and you could craft that as an amendment, I would hope. On page 16, it talks about you'll file the appeal with the code person, the code official. There's no name. Is that the police chief? I would like to see the city clerk put in there. A lot of lawyers know to use and notify the city clerk of concerns and problems, and that might be a better term, or you could have it added in with that so that we have a choice if we have a client that comes to us. Because I don't know who that city official is, or code official. On page 17, I'm concerned about due process always. As an attorney, I mean, that's a big part of studying law. I'm going to request an extension.
Okay, it's been moved in second. How much time do you want?
Well, I'll ask for 4 minutes.
Okay, all those in favor of extending time 4 minutes, vote yes. Those opposed, vote no.
We have 8 yes.
Please
Thank
continue.
you. On page 17 and paragraph 4, the failure of any person to receive notice shall not affect the validity of any proceedings. Really don't like that sentence. I mean, it's somebody's fault that they didn't get notice. I don't believe that's right. I would ask you to modify that, amend it. Paragraph 6, same page, you say in addition to methods identified in this section, the code official may provide notice by other methods. that's okay to me, but if it's gonna be May, why don't they put shall and encourage them to give every kind of notice they can to these people? Page 18, paragraph B, again about a notice. It talks about notice will be served on the holder of any mortgage, deeds of trust, lien holders. The failure of the code official to serve any person shall not invalidate the proceedings thereof. And I know that later on you talk about actually demolishing properties, and I really think you do have an obligation to notify mortgage holders, lien holders, of these kind of proceedings. I think it puts them on notice that, hey, you've got a problem with your owner, or a landlord who may happen to be the owner, and maybe, you need to be aware of what's going on here. And I think more notice, not less, is good. And, I definitely think you need to be notifying lien holders on these properties. That was on page 18. Page 19, you talk about a cessation of construction for 2 years. I don't have any comment on that. On page 20, you talk about this section, unreasonable repair means the repair costs exceed 30% of the replacement value. Now, this is where I could get into a lengthy discussion. Who's the expert again? This expert, this code official person, is going to be an expert on construction and tell us that this property costs so much to do, and where is he getting his information from and his expertise from? Was that a 2-hour or a 2-week course? I don't understand that. I mean, you have somebody that actually knows how to estimate repairs, that's fine, but I think you need to identify that. And I'm not trying to make this so cumbersome that you can't enforce it, but I mean, I've met some code enforcement people, and I don't think they're home builders, and I don't know in talking to them that they knew a whole lot about home construction or what it costs to do repairs. They probably knew about how to get rid of, weeds and things like that, and I understand that. 21 this is a very narrow appeal. It leaves very, very few grounds for an appeal, which means that original code enforcement person really has a lot of power. 22, will this stop work order have any hearing? Is there a right to an appeal to tell somebody to stop work on their home or stop work on their business? I think that should be discussed. Under definitions, weeds. Are you exempting wildflowers? I actually saw somebody growing bamboo in Oakland the other day. It's like 12 feet high. It's kind of pretty, but I wouldn't have planted it, but somebody had it and it's growing. I think you ought to define these weeds by what is growing in the middle of the 600 block of Jackson and the 700 block of Jackson. That looks like weeds.
Your time has expired. Thank you.
I think I can, okay.
It's been moved and seconded to extend the time for 3 minutes. All those in favor vote yes, opposed vote no.
We have 8 yes.
8 yes, please
Thank you, I
continue.
have to finish because I have to get a drink of water. Anyway, so I'll hurry. At the end of this, page 39, it talks about moving buildings, and I have a concern about this because I actually have a client that has had to move some buildings for zoning, and that's fine, but I could see where this code might be interpreted that those metal sheds are now buildings, and then we have even more problems to get rid of them, and I think you need to exempt smaller buildings and structures, i.e. Metal sheds, things like that, to keep them out of, being placed into a major code and a whole lot of cost. Otherwise, you might have a situation where, under the Clean Water Act, they originally talked about navigable rivers, but now they're talking about mud puddles. I'm just wondering how navigable that is, but according to somebody in the EPA, it's now navigable. And I don't want to see that kind of situation replicated locally with a bureaucracy. I hope you'll, I hope you took some notes and that you'll at least consider these things. I would have liked to have seen this put into a committee and where the public was invited to actually talk and tell their concerns, so we could have a discourse of all the people in the community that had concerns, and maybe, at least apply some legal standards to some of these questions. Thank you for your time.
Thank you, Mr. Ledbetter. Next is Aaron Edwards. I'm sorry, Mr. Schmidt had a point to make first.
Well, I just wanted to address a couple of the issues brought up there. The first is that there was a citizens committee, I believe, that reviewed this extensively over the past several months. Further, on page 20, when we talk about in this section, unreasonable to repair means that repair costs exceed 30% of the replacement value of the structure. The next line on that says, as established by the Shawnee County appraiser, so that is not going to be done by the code enforcement officer. It will be actually the appraiser that determines that value. And the other point that I wanted to have addressed, and I can't remember if this happened in a conversation between you and I, Chad, or if this was in the actual discussion, one of the work sessions that we had on this, but the idea of painting in the winter, I believe there's a provision that allows for us not to have to paint in the middle of December.
I recall that. Would you like to speak to that, Mr. Sublett?
At the end, at the end of the 60 days, when it moves on to prosecution, prosecution will have the discretion to determine if it's January and it's been 30 below for 2 months. There'll be evidence presented to determine whether or not a continuance should be granted so that something can be painted. It's just like any other prosecution. They're going to weigh all the factors and determine, is this something we want to move forward on. So some of that will be prosecutorial discretion, or the judge can always extend that prosecution if necessary to allow for 70 days if we need to get it painted in March instead of December.
Thank you. Is that?
I think that answers my questions. Thank you.
Okay. Mr. Campos?
Thank you, Your Honor. Thank you, Your Honor. I would just like to bring up that people have issue with the county appraiser, and adding another component into this through the county appraiser, once again, it makes it you could effectively be dragging people through the mud through this process. And I choose not to be that intrusive. Just something to keep in mind. People fight back and forth all the time with the county appraiser. And it's not because the evaluation is true, it's because it's not. Thank you, Your Honor.
Ms. Hiller?
I just wanted to point out one, similar to what I did before, just for understanding of Mr. Ledbetter and the public, and even the council, that most of the items that are in this document are ones that are brought forward from our old code. When you've got a model code, it's sort of a fill in the blank in terms of what your fees would be and some of the details like that. So none of those are new. They, for better or for worse, they're being carried forward exactly as they were before. On the appraisal and inspection issue, the appraisal doesn't change much. We have had some problems with how estimates have been done. Most of us have sat through some of these demolition hearings. I am hopeful that the training will help with that, and they've also learned that you don't use just a stock formula to fill in the blank if it's a historic structure, for instance, and you wouldn't put siding on it. So we've got training that hopefully will help with that. And then third, a couple of those pieces, like the moving houses and so on, it has been challenging for reading through this because the IPMC itself is not in this document. So some of these specifics that we're looking at, you have to evaluate in the context of that model code as well. And so just to kind of reflect back, they've done good work on it.
Other comments, Mr. Schmidt?
Yeah, my comment on the appraiser, Mr. Ledbetter brought up a lot of very good points, as he usually does, that need to be considered. And it was not an attack on the appraiser or any code enforcement official. If you have a more a better idea of somebody that could provide that, that assessed valuation of what of a property is, I would be more than happy to listen to any amendments that would replace that. But I think the idea that we have a county appraiser that's appointed to that position to do that exact thing, granted that sometimes they make mistakes as well, I think that would probably be about as high of a bar as we're going to be able to set in that process.
Okay.
Thank you.
Our next speaker is Aaron Edwards, to be followed by Joe Charest. I'm sorry, Mrs. Ortiz, excuse me, Mr.
Real quick, Chad, is there anything in here that grants, like apartments, duplexes, bigger buildings, more time?
No, it applies to any existing structure within the city.
Did the committee, do we know if the committee's looked at that?
I could ask Darren.
Are you asking, like,
Um,
do they have more time to make, is this in that
Repairs.
sense to what we've talked about with the repairs?
I mean, we have somebody that, she inherited, several townhomes that need repair, but, I mean, I don't think she could do it in 90 days. That's what I'm saying. Is there something in here that would,
No, the timeframes apply to any existing structure. It doesn't differentiate between the type of structure
so
it
the
is.
chair never looked at that?
Well, but, excuse me, but didn't you say that if there is a problem meeting the deadline, you
Yeah.
can, that's something you talk
yeah,
to
the-
someone about and they can extend the deadline? I thought,
If
that's what I
there's
heard you say.
Yes, if there's a violation, let's say, I'm just gonna pick one, that the house needs to be repaired. 60 days is run, therefore it's cited, it goes to municipal court. The evidence is presented to the prosecutor that's, look, I inherited these 5 townhomes. I'm gonna need another 4 months to look at this.
Let's
The
say
pros-
50 townhomes.
50 townhomes. The prosecutor has the discretion to either file that case or not file that case or continue it. The judge would also have that discretion on the criminal side to continue that. So there's always that option of continuing. The 60 days is, at the end of 60 days, it's going to prosecution, and the 60 days is on the outside. And so the prosecutor could always extend it beyond that 60 days. I mean, because the issue that you get into is, what's your time frame? Is it 90 days? Is it 120 days? Is it 150 days? Is it 180 days? Those are difficult questions to answer and try to put timeframes on. And the feedback that we got from several different places was, it's taking 2 and 3 years for these properties to get addressed. That's where the not to exceed 60 days came from.
Thank you, Mr. Mayor.
I think Ms. Hiller was.
In relation to that question, this code does provide the code officer with the authority to grant someone, if the person wasn't gonna have the place occupied, it can be vacated and secured for up to a year, and it can even be extended beyond that. So, depending on the circumstances, there's that option too. Thank you.
Mr. Campos? None, okay. Any other questions or comments? We have now Aaron Edwards. Your time starts now, not from when you started standing up there.
My name's Aaron Edwards. I own a AV automation company based out of Lawrence. In our industry, training, education, and consistency is absolutely key to what we do. One thing I can tell you about training, we send our employees through extensive training, and it doesn't always stick. You can put a person in a class, you can put a book in front of them, and it doesn't necessarily stick. I have a number of employees that I cannot put on certain jobs because they just don't understand the job. They don't understand that particular aspect of training. And here you're going to be making a code enforcement officer a jack of all trades. I really hope you're getting exceptionally bright people to be your code enforcement officers, people who are Mensa members, so that they can understand the depth and breadth of what they need to understand for housing, for safety, for every aspect of a building. The building is a system. It's not just a lot of people don't understand that a house is a system. What we do is automation and control. We do electronics, but in that we have to touch everything from lighting to the HVAC to solar to windows. Every last aspect of the building is something that we control and interface with, and we have to train and train and train just to keep on top of that. And we have exceptional people in our organization, and they can't understand the depth and breadth of what needs to be understood. And here you're asking that the code enforcement officers would be given that responsibility. And there's a line from a comic book and a movie, with great power comes great responsibility. You're also giving these code enforcement officers almost an unlimited power. The big issue I have is that they have the power to just walk into my home because they feel like it under code enforcement. In 1791, the states ratified the 10 amendments to the Constitution. During the initial founding of the country, it was so important during that chaotic time that those 10 elements, specifically the Fourth Amendment, the search and seizure, to not have that type of thing, to keep the government out of my door. That you can, if I'm not keeping my house up, of course, I can understand those aspects. If it's a danger or even an eyesore to the neighborhood, some neighborhoods have homeowner associations and wealthier cities with wealthier neighborhoods. Again, that boils down to jobs. We don't have a lot of great jobs in this city. My company doesn't do much business in Topeka because there's not that many customers of that echelon in this city. We market, but we don't see them. We do a lot of work in Lawrence, Kansas City, Leawood, etc. And those are nicer houses. The issues that we run into here, we have more code violations because we have less income. We have more crime because we have fewer jobs. But we don't need to give code enforcement officers the ability to egregiously violate our Fourth Amendment rights, walk into our homes with just their badge so that they can walk into my home because they feel like there's something that they need to look at. The Supreme Court has time and time again that suspicion, that you have to have a reasonable suspicion, not just cause is not just cause. And for an administrative person to be able to take criminal action and get because in order to enter my home, you'll need to have a warrant, which will have to be issued not by a municipal judge, but by a county judge, which under criminal law. And for that to occur is a violation of everything sacred in the United States.
Okay, your time is concluded, or would you like additional time?
2 minutes would be.
Okay, it's been moved and seconded to allow 2 additional minutes. All those in favor vote yes, opposed vote no.
We have 8 yes.
8 having voted yes, you may continue for 2 more minutes.
Thank you. I understand the appeal of having a consistent code to enforce, a code that other cities have used, something that is harder to fight in court, something to help clean up the city. I look across from my house and I see a number of homes which are frighteningly out of any kind of code specification. One of the issues in this city, I believe the code has been unequally applied. Some things are ignored and not seen, while other things are focused on with a microscopic lens. And hopefully a new code would equal out that, where, as with other laws, it should be applied equally to all citizens. The aspect I would really encourage the council to consider and to completely strike down is regarding what would be an illegal entry into citizens' homes. Recently, Homeland Security has just issued a request for proposal for software developers to create a vehicle tracking system that'll utilize cameras located at traffic lights. This will be tied to a centralized national database allowing people to be tracked. We know the NSA listens to everything we say.
Okay, let's keep your comments on
If you'll allow me,
the ordinance, yes.
All politics are local. The only thing we can do, we cannot affect Washington, but we can affect our laws here. And we can say no right now to this kind of language which allows for intrusion into our basic civil liberties.
Okay,
Thank you.
thank you for your comments. The next speaker is Joe Charest, to be followed by William Gomez.
My name is Joe Charest, and I am with Fox Ridge Townhomes Neighborhood Association, and I'm in Mr. Harmon's district. One thing I just want to say is I used to be kind of one of those people that kind of blew off politics and getting involved in the process and whatnot. And my passion for getting involved in this came when we were doing a thing over with the Topeka History Geeks at the Ritchie House, and I saw some abandoned properties that had gutters hanging off of them and unsafe, and looked like they had been vacant for quite some time. And so that's how I began to get involved in this. And I've said this before. I've lived here since I was 16 years old, and I have seen the same things over and over and over again. I've seen buildings for 20, 30 years that have been vacant, and nothing's ever been done to them. I've learned a lot in this process. I've learned that we have an emergency repair program. I've learned that we have an accessibility program. I've also learned that we have a voluntary demolition program through H&D. And so I know that there are services out there available to people of low income, and I also know that Lazon Grays is working with interested parties to get some training in the neighborhoods to address some of these technical issues that aren't so technical, like helping a resident paint their house. I do know that we are all working on these things, and I know that Darren is working on trying to get things moving in a positive direction. So what I would like to say is that I would like you to vote in favor of this ordinance so that it gives us a clean slate with our code enforcement, because if we don't have something to go off of, if we don't have a foundation to go off of, then we're still stuck at the same spot that we're stuck at now. And we can keep spinning our wheels and keep spinning our wheels, or we can actually make some serious change in Topeka. And I think that this actually gives us some teeth and it allows us to have some change.
Okay, thank you. Thank you, Joe. Mr. Campos, you had a point.
Thank you, Your Honor. I just have a quick question. You served on the committee, the citizen committee for the review of this, correct?
The Citizens Review, the CAC, or the Code Compliance Committee?
No,
The
which
CCC.
committee? You served on one of the committees.
I'm on the Code Compliance Committee, yes.
Okay.
Thank you. And were you provided a copy of the IMPC?
I have this document right here. This is the only thing that I've ever been given, and I have read through it briefly. I was supposed to get a copy of the actual booklet itself, but one has never been given to me.
So would it be fair to say that your committee, the CCC, has never been provided with an IMPC booklet?
That is correct.
Thank you, Mr. Trey. I appreciate that. Thank you, Your Honor.
Thank you. Other questions? Next is, thank you, Joe. Next is William Gomez, to be followed by Patrick DeLapp.
Honorable Mayor, respected council and staff. I'm William Gomez, and I am here specifically to ask for your support of this IPMC. I ask your support approval of the IPMC. I look to this to improve, assure a safer, cleaner, healthier community, which is what we all are charged with. I look forward to a eventual improvement, and I say eventual because it takes time, of property conditions citywide. as the Oakland NIA Committee rep to the Summit Task Force and as a member of the Code Compliance Committee, and more importantly, as a resident of Oakland, which is experiencing property value declines to an increase of properties in need because of current, outdated, and mostly unenforceable code ordinances that currently exist, that we are working under. The IPMC is a much-needed process to bring about change for the better, and as we all know, change is not easy to come about. The task force committee that I worked with has done a great service to our community by volunteering and being available to be a part of this in partnership with city departments, legal, code enforcement, H&D, Mr. Darren Scott, just to name a few. Accordingly, the IPMC is a working document with the ability to change when needed, and I think that's an important note to consider. It is a working document which is, can and will probably be changed as the process moves forward. I thank all who took time to care to participate, as some of you on the council did, and I thank you for that. This is a product of working together for the better of our whole community, city. And in my final statement is, I'm going to ask you all to please support this. It is a document, if I may comment, I was provided, and some of us were provided with copies of the IPMC, which was also made available to us through the website, so that we have the same copies that you all have or had access to them, just to make that clear. Thank you.
Mr. Gomez. Any questions? Okay, next is Patrick Delap, to be followed by Eleanor Cowell.
Hi, I don't right now support this code, just because the way it's been ramrodded through and the really lack of public input. From what I understand, I knew people that was on the committee, good people quit from there because input was not allowed. They were basically lectured to. Just last week, one of the persons on the committee was that he's not going to support this at all unless he gets answers. I understand an attorney named Luther talked to him just a few days ago for a couple of hours and tried to convince him, and that was the only time he was getting answers given to him. I have a problem with the code not being accessible. None of the committee members had a copy of that code book. They said, oh, it's online. Well, I couldn't print it off from line. There was questions. I was told which code book we were going to be using no more than 7 days ago. Well, which one is it? The 98 code, the 2008, the 2012? By the way, the 2012 is obsolete. April, right now, they're printing the 2015. I compared one of the two. There's 10 pages of changes in those codes per year, approximately. We're talking about a code of what, 40, 45 pages? That's substantial. I have problems with the grandfathering clause, historic structures. Does that mean it has to be on the historic registry, or this? You realize in the code that GFRs are now required in kitchen? Oh, that's only going to cost you $230 if you get the right electrician to get in there. We've also stepped backwards in the code as far as habitable space in a basement. You're supposed to have a window 42 inches off the ground, big window large enough that a fire department guy can go through with his oxygen, things like this. Guess what? We can go back to those little tiny windows, so you lose that area of egress. What a step backwards. I do disagree with the idea of prosecution at the same time of civil and criminal prosecution. That's called double jeopardy, and we made the paper 3 years ago when we lost big time doing that to somebody. The court told us, you pick which way you're going to do it from the get-go. You can't choose later. You can't do it both ways. I have a problem with sending the letter off by first-class mail. The city had to pay out $23,000 to an individual who was sitting in the VA in Kansas City. He never got that letter. City came in, cleaned up his property. And this is a guy that used to own a circus just past Hummer Park, which was not called that at the time. They took his circus equipment. He took 2 vehicles, new engine in it, and they disappeared. You know, they were told, well, we put those cars, we threw it away in the city dump. Well, I don't have a city dump. The city paid out $23,000 to that man because he was sitting in the VA office and they sent it first-class mail. I don't like the idea of it is unlawful to transfer ownership when there's code problems with that. It's a huge problem, gentlemen. We've got a person going to a nursing home or in a nursing home, and they can't sell it to somebody else and maintain that property without having it totally fixed up. She doesn't have money. She's maybe on Medicaid. That needs to be changed. Motor vehicles, having plates on them, they can easily find out who owns them. It's called the VIN. Now, the city of Topeka, we only check back 3 years on it. They don't know how to press the button of archive, and I was told this by a state highway trooper of how to get in those files, things like this. And so you can find out who owns the things. All metal surfaces must be painted, things like this. If you take a look at those steps outside, we've got rust coming off the rust, we've got salt spalling, we've got a big piece of stone, a couple of them falling over like that. Why can't the city take care of their own stuff?
Your time has expired. How much more time would you like? Would you like to
3
extend the
minutes.
time
3.
for 3 minutes?
Yes.
Okay, so moved and seconded to extend his time for 3 minutes. All those in favor vote yes, opposed vote no.
We have 7 yes.
Having voted yes, please continue for 3 minutes.
Thank you. Foundations, walls, 304.5. Code disallows cracks in the foundation walls without tying that to they're leaning in, there's big holes, things like this. It just says a crack. 304.7. Now this, written by professionals, what do they mean by roots and drainage? It should be roofs. Nobody caught that? Glazing on all windows, things like this, crack-free. Housing quality standards allow cracks in windows. They have to be a certain size, tight, and things like this. But this doesn't allow any. Deadbolts, double deadbolts are not allowed in houses anymore. That's where you've got a key on both sides. So when they break in, they can't get out. Handrails need to be better defined. When are they required? All they say is they should be in good repair. Well, I guess current code says we need them when you've got like 4 or more risers. Right now, it doesn't even say that. I can have 20 risers. Risers is a step. We don't need them. If it's not there, don't worry about it. Gentlemen, we should be worried about that. Same thing for handrails around a porch or something like this. Unsafe conditions, again, going back to spalling, fracturing. Take a look at our sidewalk out here. Common hallways, lighting, I have a problem with that because we're using old definition of 60-watt incandescent light bulbs. We've got much more efficient lights out there, that don't even use close to 60 watts. We also have lights right now in factories, warehouses, that when you walk down there and they sense someone coming, they light up. Go to Dillon's shopping out here in Gage. It's in their freezers. They don't light up till it sees you coming, and that might be all right. Floor surfaces in bathrooms. I can't have a throw rug in there now. That's what the code says. It has to be an easily cleaning surface without having that exception that it's something you can pick up and throw in the washer. I do agree, I have a problem with the threat of arrest or fine for not letting the inspector into your house when he asks permission to go in. That is a violation of my protection I should have of unreasonable search and seizures. We want to go through training. Well, I think we need to go through even more training with the head of the department. What happened over there in Munson, gentlemen, I will say that is trespassing. If the city's contention is that, well, there was a law being broken or something like this, what is he doing? Bringing the public on there and the media on there. He is endangering the public and the media, bringing
you
to
have
fight
to
that crime.
put your comments on what we're talking about, which is this ordinance.
That's trespassing. It's curtilage. We have the right to be secure in our property. Curtilage is defined by a fence up there or bushes, things like this, and that was violated.
Okay, thank you. Your time has expired. Next, we have Eleanor Cowell, to be followed by Andy Landis.
Hello, I'm Eleanor Cowell, Chair of Seward Avenue Action Group and Secretary of the Oakland Neighborhood Improvement Association. It seems like every time we have an NIA meeting, someone complains about something that is not being done that's not up to code. So I really would like you to adopt this as amended because it has teeth. So, and what I hear is that there are, in these complaints, that the process is so long that a lot of times nothing happens. It's just, even though it may be in the code, it just doesn't happen because of the process being so long. And also that we don't have enough code officers in the city. So that may be something that needs to be addressed in order for this to work. As I've said before when I've been to the council, the project that SAG is working on is improvement of Seward from Branner to K4. And I've also said we are doing this in little pieces. Well, one of our pieces is the streetscapes project, which is from Branner to Sumner. And I drove that today and I looked. There are 5 businesses that are boarded up, and there are 3 houses that look to me like they're all out of code compliance. That's 0.8 of a mile, so that's 8 properties. So just in that little bit, I can see that we really need this. And I thank you for your time.
Thank you, Mrs. Cowell. Next speaker is Andy Landis.
Good evening, Mayor and Council. I had a concern with that lady said earlier about the 104.3, the right of entry. I've just got a concern with that and the new code. And Mr. Ledbetter had a good summary of some of the other points I was concerned, so there's no need to rehash it. So that was my input, basically.
Okay, thank you, Mr. Landis. Mrs. Ortiz?
And Andy,
I'm sorry, did you want him to come back?
please.
All right, Mr. Landis, would you want to step back to the microphone? Mrs. Ortiz
Did
has
all
a
of
question
your-
for you.
Did all of your other questions I know you called the council office, did all your other questions get answered?
Yeah, basically, in listening. This thing kind of snuck up on me. I hate to be the low information citizen, but I only caught wind of it at a landlord meeting 2 months ago. Hey, you hear there's gonna be a new code, and I didn't realize all this was going on until it kind of hit the paper. So I'm kind of disappointed that it didn't get to an NIA meeting that, I attend with you all the time, or the landlord meeting. It's just kind of taken as a surprise and haven't had time to absorb all this.
And did you hear that he said it would take effect in July?
Yes.
Okay, just want to
Thank
make
you.
sure you're satisfied.
Thank you.
Thank you,
you.
Mr. Mayor.
I would like to have Mr. Scott, if you could come up. There's been a lot of comment about how there hasn't been an opportunity for public input or that it has been closed. I would like to have you speak to that. When the committee started, were the meetings open? Were there opportunities? And I believe you went to some NIAs. If you could describe some of the process that we've gone through in the last 6 months. It's now April. I don't know, when did the committee start?
Mr. Mayor, Deputy Mayor, City Manager, and Council, this process started after the 2013 summits. There was actually 2 held where they had open town meetings, and they categorized the biggest needs, which we have in the original committee. We started the community commitment team when I came over at the very beginning of October. When we went through this process, what was identified was the stakeholders to get this product out to the community the best the way that we could. And then the neighborhood task force has already been meeting monthly with one of our H&D representatives taking notes at every one of those meetings. Then the CCC, the Community Commitment Team, or Code Compliance Committee, branched off from that to do their own study, which is what Mark Galbraith has done in his group. And as we met, we went to the neighborhood task force meetings once I came on board as a different perspective, along with Rosanna Haugen, who was taking the notes. And then the Code Compliance Committee, We met with them too. We met at the police department several times, and then Mark moved the meetings up to actually the code offices on the 3rd floor of the Madison building. Once we got up there, we just started going through the processes of what the wish list was from the community, how this was going to take effect, and I can say that wish list that they presented to us at the meetings, because Mark and John were part of the commitment team, which is also part of the organization of the city as a whole. And during this process also, we were going to the NIA meetings. I tried to hit as many NIA meetings as I could. I've been out on several of them. One of the things that I found, and it was a frustrating point for me, was when I came over, was the NIAs were stacked on top of each other, 3 and so a night, and so it became fairly difficult. I had a medical issue that popped in that time frame, had to take care of. So, and I got back out and started working again and made as many phone calls as possible. We've had 3 work sessions here at the council. We've had, I think, we could ask Tim Rincher, he's been here. But I think we've had 4 articles that have come out. The first one in October when we came out. We followed up with that, several articles, and then we had another one on Monday. And so a lot of the groups that have come forward today, I'm sorry, I don't. We've been working on it for over, coming up to a year since the summits were held in 2013, so.
Okay, thank you, because I don't want to give people the impression that we haven't. I mean, I think it's been a reasonable process of allowing people to provide input. And of course, there are always times when people don't find out about an issue, and we're aware of that. But I think we have attempted to keep people informed as much as we can. Okay, and then other council members have comments. Mr. Campos?
Thank you, Mr. Mayor. Being kept informed is very important. And as Mr. Scott, I have a question for you. You said you've been taking or having monthly meetings with H&D with your CC team, and then you've also been meeting with the CCC. Why haven't we been provided any of the minutes of those meetings?
Well, I can tell you the meetings were for, well, I'm going to refer to Chad on that. We had the internal meetings with H&D, the ones that the neighborhood task force were involved in. Roseanne Haugen was there because it was a formalized task force that came out of the summits. And then the CCC, the Code Compliance Committee, was branched out of that. And they met, we were in there to bounce off ideas and back and forth so that we could work through the processes.
Okay, Mr. Sublette, did you want to comment on that?
Yeah, just if I may, Mayor, Councilman Campos, I think at each work session, we referenced the community commitment teams and the larger teams. We referenced that they were continuing to meet. We referenced the subjects about what we were meeting about. In fact, at one point, I listed every representative of every person that sat on that community commitment team. We gave all of that information to council. I won't speak for Mr. Scott, but I never received any questions regarding those meetings from any council member, but we did inform council on at least 3 different occasions and 3 different work sessions. Those meetings were continuing, who was a part of those meetings, what was being discussed at those meetings. And I think there were 15 different NIAs that I mentioned at one point that were part of those meetings. So I just wanted to put that out there that this in no way was a secret process, that we discussed it on numerous different occasions, at least I did with this body.
But if the purpose is to provide information to this body who makes the policy, let's make it very clear. You do work for the city, both of you, but you don't make the policy for this city. We do. We're elected to make that policy at the direction of the city manager. It's important, if we have information going both ways, we need to be provided those minutes. Yes, I appreciate, well, I'm not done. I appreciate the token, but not giving that information to us at all, and then not providing the CCC a copy of the IMPC code. I really have a problem with it. Now, by no means, do not take my comments, those who are sitting in the audience or those who are at home. I appreciate the civility that has occurred here. We need to have interactive and being engaged with our constituents. This is a perfect model of how we should work together. But you've done the first half. What you're bringing forth is a recommendation. We shouldn't adopt this. This should be remanded within a committee with our own body so we can discuss those policy issues as policymakers. That's the reason why we're elected. I think that's very important, Mr. Mayor. I think that's extremely important. You should be leading that charge. You represent the city at large. This is your conception. All I'm saying is we're not done with it. We need to speak on our own, and we also need to remand this back to public health and safety so we can speak about this. Thank you, Your Honor.
Mr. Campos, several members of the committee said they did receive the full document, and they looked at it. I didn't say that. Mr. City Manager, do you have a point?
Thank you, Mr. Mayor, and Mr. Campos. I appreciate the comments, and when this body gets together, there's no expectation that everybody will agree. You stated it very correctly. People have the right to disagree with each other. But I do not like the attacking of a staff member who has been very committed to the city for over 25 years. And to put into the statement that he's holding things out, he's consistently operating in a manner that is consistent with how we as a city operate. And we have meetings, we have task force, we've come back. This has been the most discussed item that we've probably had. So I appreciate your comments, and I appreciate even if you don't like certain things. I think a lot of statements have been made tonight and have been built on the illegal search and seizure, the 104.3. Maybe the city attorney can talk about that and what the specific code says. I just think we need to remain civil, and I get a little bit sensitive when we have somebody who's been very dedicated working on this, and them being attacked. So I just make that statement.
Well, and the only item that I add, and I think, Mr. Scott, thank you. I don't think, unless there are other questions for you. I think that, as has been stated, this is an issue that's been before us for a long time. It's not perfect. There won't be whatever. The U.S. Constitution was not perfect. There were amendments made. We adopt something. We see how it works. There will be changes. We will see things that have to be amended, have to be corrected to make it more unique to Topeka, and that's the way, that is the process. But I think to labor it on, to work on it, it could be something that, in 2 years, we still won't have everything the way everyone thinks it should be. So we take that step forward and we adopt the new compact, and then we work on it and to continue to improve it. Mr. Leesland?
Thank you, Mr. Mayor. First of all, I want to say that this process has been extremely lengthy. As soon as we got elected, we had the summits. The summits were the public expressing what their main interest was. The number one thing that came out of that summit was code compliance. The number one thing. It is not something that the city manager decided that it was going to be his thing. It was not something that anybody decided. Our role here as policymakers is to ensure that we are listening to our constituents when they're asking us for something. Our constituents very clearly stated, the people that are extremely engaged in their neighborhoods, that code compliance was their number one concern. This has been happening since April. With open public comment. 3 summits? Was it 3 or was it 2 summits? So 3 summits. Not only that we have the 3 summits, but it's been brought to this body. I find it, and I seldom speak up in a negative fashion, but I find it extremely disheartening that we are asking for our staff that has been working extremely hard for documentation. If we are interested in receiving minutes of documentations, we should be asking them before, not today, which is the day of us going ahead and making a vote. We've had plenty of time to evaluate this. We have communicated. It is extremely difficult when you're trying to engage a constituency of over 127,000 people to get every single person informed with every single thing that we want to communicate to them. It's hard. It's extremely difficult, and our staff has been working tirelessly. Every single time that I meet with Mr. Scott, that we talk about issues that are happening in my neighborhood, the code issue comes aboard. When I go out to different places, we're talking about this. We have so many people standing here, and it's disheartening to me that although I do respect the differences in opinions that constituents have had, for example, Mr. Ledbetter made some excellent points, and all of those points were addressed today. We're not asking for somebody to go ahead and make amendments in less than 60 days if they're not going to go ahead and, make enforcement. We have, in order for this to be successful, we're being told that, hey, you know what, it's not going to be a police officer. We're going to have a person that is going to need police officer access in order for them to be able to make an entry. Every single thing that has been said has been listened to, has been answered. It's unfair for us not to listen to what is being said to us and become set on a stance for whatever purpose. So what I'm imploring this body is we're not gonna agree. 100%, not all the time. But I think that this is what our constituency, what our citizens have been asking for. Our staff has done a wonderful job of trying to bring us a vehicle that works, that has teeth. And what I implore my colleagues is for us, with this agreement, to move forward and then use this to work together to make the amendments that we need once we're able to have something that has teeth and is able to be implemented in our neighborhoods. Thank you.
Thank you. Okay, so we have a ordinance going by 5A that's before us. It's been amended and it's been moved and seconded to be for passage. So we're, in a sense, discussing that right now. Mrs. Hiller?
Thank you, Mayor. I think I've got just a few comments that I brought this evening. First, though, I think the issues about public input are valid. There have been requests for public time when there was time for the council to talk about this and for the public, and we haven't done it until tonight. So it's so, and it also, this was a difficult, since the summits, this group has been working along, but for a chance to take this ready to go and ask a lot of questions, we haven't had that. And this is also a tough document to get inside, to access that IPMC, the model code, and then to line up the proposed detail to it has been tough. So that's just been out there. In terms of my position this evening, I'm ready to move on this. So no question about that. A couple of comments about where we are. I do appreciate the city manager's draft directive about this, and I certainly hope that it will become final and move forward as a companion to this document. I really want to thank the staff from legal and all the staff that worked to get us this far, and then particularly legal, who spent a fair amount of time with me. I had a lot of concerns that I did submit, and the legal staff was responsive. At the same time, I had a whole string of questions about what does this mean and how will this work and how will that work, and I have not gotten a response on any of those. And I'm disappointed in that. Still willing to move forward, but I think the kinds of questions that I had were all representative of concerns and issues that my constituents have had. I have two requests then from today. One would be that a public meeting is held between now and July 1st, either as part of a council meeting or separately, so that the public, people who are here today and others that do have questions and concerns, can come and ask all those questions. How will this work? How will that work? And the second is that I do hope, as work on all of this progresses, I sat down and looked at the website today just to check it for the postings of code complaints on nuisance and on housing. If you would all just realize that each of us in districts 1, 2, and 3 have, in some cases, as many nuisance and housing cases in our districts as all the rest of you combined. And I hope that as we asked for time to work on this or help on these issues, that you would support that. Thank you.
Mr. Sublette, did you wish to make a point?
There's been lots of back and forth about this right to entry issue. Within the IPMC, and I'm not going to read it all, there's 2 single-space columns defining right of entry and what's allowed and what's not allowed. But just briefly, searches of a private residence to gather information for the purposes of enforcing codes, ordinance, and regulations are considered unreasonable and are prohibited by the Fourth Amendment to the United States Constitution. Reasonable cause in the context of this section is distinguished from probable cause, which is required to gain access to property in criminal cases. The burden of proof establishing reasonable cause varies among some jurisdictions. Usually an inspector must show that the property is subject to inspection under the provision of the code, that the interests of the public health, safety, and welfare outweigh the individual's right to maintain privacy, and that such an inspection is required solely to determine compliance with the provisions of this code. Many jurisdictions do not recognize the concept of an administrative warrant. The state of Kansas does, and there must show reasonable cause in order to gain access upon refusal. The burden of proof is substantial, often requiring the code official to stipulate in advance why access is needed. Usually access is restricted to gathering evidence, what specific items or information is sought, its relevance to the case against the individual subject, how knowledge of the relevance of the information or item sought was obtained, and how the evidence sought will be used. In all such cases, the right to privacy must always be weighed against the right of the code official conducting an inspection to verify that the public health, safety, and welfare are not in jeopardy. And it goes on from there. So to have a concept thrown out there that the code official can just push their way into their house and do what they want, it's not only clear in the language of 104.3, but it's clear in the commentary, it's clear in Kansas state law, federal law, and the United States Constitution.
Okay, thank you. Is there other comment on this, Mr. Schmidt?
There's one other issue that was brought up that I would like to address, and Chad, I might want you to address this as well. That was the idea that administrative and criminal proceedings cannot proceed at the same time. And I think the double jeopardy idea, which I think is a misunderstanding, it would be similar to a traffic offense where you could have a criminal prosecution as well as, say, your driver's license being suspended, which would be the administration portion, and a criminal portion, which would occur at the same time but in two different venues. That is the way that I see this being written and not being a violation of double jeopardy. Is that correct, Chad?
Mr. Chad, would you like to respond to that?
Mr. Soleil?
I'm sorry, Mr. Mayor, if I may respond. Councilman Harmon, yes, that's exactly right. We specifically state Schmidt, Councilman Schmidt.
We're about ready for a break.
Thank goodness.
He's better looking anyway.
Yeah. Yes, that's exactly correct. We state in this ordinance that an administrative process does not bar criminal prosecution. And I like to use the example of a DUI offense, that in a DUI you can be criminally prosecuted at the same time there's an administrative hearing to determine whether or not your license is suspended. That's not double jeopardy.
And that particular issue, has been a problem in the past, because we went to administrative hearings, which take a span of time, and then we would go into the criminal, and that's where they end up being a year without anything being done because of that process. Mr. Harmon.
Thank you, Your Honor. Mr. Colson, the point of unanimity this evening seems to be that our current code is inadequate, and its enforcement is lacking, or at least uniformly, and that enactment, or at least consideration of this code is an improvement on what we have currently. Be that as it may, can you work with staff to develop some quantifiable metrics so that we can begin to measure the effectiveness, if this is adopted, so that a year from now, 3 years from now, 5 years from now, we can have some data so that we can compare our code enforcement under this new act, if it's enacted, versus under our current act. Is that possible to develop those quantifiable metrics?
Mr. Mayor, Councilmember Herman, absolutely, and that's a direction that we're going, not just with code, but throughout the entire city, from a good management and accountability standards to make sure that we are providing the customer service that's anticipated by the residents of this community. So yes.
Great. Thank you very much. Thank you, Your Honor.
Mr. Campos.
Thank you, Your Honor. I just have a quick question to the city manager and to the lead of legal. Budgetary impacts. In your discussions tonight, you said that there would be an extension, 60 days, 90 days. It seems a lot of back and forth. Do we have that built into the budget to accommodate what is needed by our legal department in light of the cuts that we made in the 2014 budget and going forward for 2015?
Mr. Mayor, Councilmember Campos, yes, we have anticipated what the budget impacts of the activity, and we've accounted for that in our budget, yes.
Thank you, Mr. City Manager. Thank you, Your Honor.
Mrs. Hiller.
I have two very brief things that, for the record, I was contacted by the Shawnee County Landlord Association today.
As were all of us, I think.
Okay, so if everybody knows, I promised that I would mention that they wanted us to delay, so that people knew that. Second, there is a lady in the audience, Mrs. Joyce Ritchie, who didn't realize she needed to sign up before 5 o'clock. her comments are here and some photos of property on Washburn, a couple properties that she's concerned about, and I will pass them around on her behalf.
Okay.
Thank you, Mayor
All right.
Lopez.
Mrs. Delisle?
Councilwoman Hiller, I had an opportunity to speak with Ms. Eklund, the president of the association. After speaking with her, it was really interesting. She had just finished speaking with Mr. Scott. She was very happy with Mr. Scott's call. And not only that, but further, when I went into further detail about the explanation of the volunteers being recruited to help in the neighborhood, she was very excited about that change. So just to let you know that she was happy.
Okay,
And
thank you.
if I may, in response to that, she was, and as part of that, just, there was a comment made by someone earlier. A lot of the members of the Shawnee County Landlords Association are real great people. They're not all landlords are bad guys, and so, they're a very
Okay,
reputable group. Thank you.
Thank you. We want to be able to vote here because we're going to have to change the tape, and we'd like to be able to do that first. Mr. Van Speaker.
Thank you, Mr. Mayor. The first thing that I'd like to do is I would like to apologize to Mr. Scott, to the code enforcement staff, to the neighbors who've worked on this. You all are not on trial here. The issue at hand, and Mr. Harmon nailed it, the issue at hand is that our code system is failing us. But it's not failing us because of our code enforcement officers. It's not failing us because of our neighbors who are turning it in. It's failing us in the way that it's written. So this change is a proactive response to a community-driven initiative. And I think it is an excellent example of how this body should operate. And I commend everybody who's been involved in this process. I get the public input. I understand that. But the reality is that we hold city council meetings now 3 times a month. At every city council meeting, there is a public comment section. We have talked about it repeatedly publicly. I've talked about it with constituents repeatedly publicly for months. It has been prolonged for months. So the reality is that this has been out in the open. One thing I really struggle with is when you make a claim like that, what you're doing is you're attempting, well, this is the bottom line. You can't prove a negative. And so you can say, this didn't happen. Well, how am I going to prove that it didn't happen if it didn't happen? So the evidence that's provided to us by the folks that are having to defend their position, which is unfortunate, gives us reality. But making claims that don't provide evidence, that's not reality, that's just a statement. And at the end of the day, this thing isn't going to be perfect. We're not drafting the Treaty of Versailles here. What we're doing is we're attempting to fix a problem. We're attempting to solve one of the biggest issues that impacts our neighborhoods and our home values. This isn't a bad thing. This is a very, very good thing for a large majority of Topekans. And the next step of that comment is that there are 3 types of folks that violate code. Folks who accidentally violate code, folks who can't afford to remedy the situation, and folks who violate habitually. This intent is not to go after the first 2. We're really focused on the third. The third is the person who is over and over and over again dealing with code enforcement in the city of Topeka, and we have no way to remedy this problem. We continue to have no way to remedy this problem, even with passing this code this evening, but we have better opportunity to pursue them. And so I think it's excellent that we've gotten to this point. I think all hands on deck has happened throughout this process. And again, I commend everyone who has been involved. I can't imagine your level of frustration, having gone through all of this, and then to have, willy-nilly things just thrown around the air like somehow you've done something wrong. I appreciate your work. I will be supporting this measure. I look forward to amending it if need be, because that's how, last time I checked, the legislative process worked. So if you don't like it, don't vote for it. But don't complain if code isn't able to do what it's supposed to do. Thank you very much.
Thank you. We have a motion to approve the ordinance, which is 5A, that has been amended. There is no other discussion. All those in favor vote yes. Those opposed vote no. I vote yes.
We have 8 yes and Mr. Campos voting no.
Okay, 8 having voted yes, the ordinance, IPMC, is passed. And with that, I will call a 10-minute break in order that we have to change the tape. So we will re-adjourn at approximately 8:26.